Some of you know that I did get served and I'm not allowed to talk about certain things. Not only that, that patriotic freedom fighter. My wife and I had to surrender our weapons today. Again, second time in 10 months now. Not happy.
Welcome to the channel, and in today's video I'm going to be examining statements made by Todd Bryant after he publicly acknowledged being served with a Florida temporary protection order. This is not speculation. This is not commentary based on rumour. This is evidence-based review of Bryant's own publicly broadcasted statements made after he confirmed that he had been served and after he acknowledged compliance measures had already been enforced. The question we're examining is straightforward. Did Todd Bryant continue referencing protected individuals and protected subject matter through indirect coded language after service of that order? To answer that, we're going to review multiple clips taken from Bryant's own live stream from 5:30:26. Each clip will be shown with the time that appears in the original video. After each clip, we'll break down what was said, what the surrounding context means, why these references may be readily identifiable to his audience, and how those statements could be interpreted under the language of the Florida Temporary Protection Order. Before we begin, let's establish something critical. Todd Bryant himself confirms in his own words that he had already been served.
Some of you know that I did get served and I'm not allowed to talk about certain things.
Now that fact is important because service establishes notice. From that point forward, any continued indirect references, targeted commentary, or efforts to direct his audience towards prohibited subject matter would not be accidental or uninformed. They would be considered post-notice conduct. The order prohibits direct or indirect contact involving electronic communication directed toward or concerning protected parties. This includes social media. The key issue here is not simply whether the names were explicitly spoken. The issue is whether a reasonable person familiar with the context would understand these references as identifying protected persons or a prohibited subject matter. And this brings us to the first major pattern we need to decode. The repeated references to the 911 call. For viewers unfamiliar with the background, this is not a vague or random topic. This is a specific reference to a 911 call that was placed the day that Lion 1 died. That event has been a subject of repeated commentary, discussion, and allegations across this commentary ecosystem. And within this audience, references to that call are widely understood to point directly to the events of that fateful day. Because if these references are reasonably identifiable to the intended audience, then avoiding explicit names may not avoid legal implications. So let's examine the clips one at a time. Clip 1.
I'm just going to say this. I'm not going to say anything else. 1 year ago, a 911 call was made in 4 minutes from right now. Rest in peace. We're not going to forget. We're not going to forget. This is only just starting.
Let's stop right there and examine what was just said. At first glance, this may sound vague. There are no explicit names spoken. There is no direct statement naming William Bartell or Andrea Matthews. And that ambiguity is exactly what makes this clip important to analyse carefully. The key phrase here is the reference to the 911 call. Now, for the casual viewer with no background knowledge, that phrase could mean almost anything. But Bryant's audience is not hearing this in a vacuum. Within his commentary ecosystem, the 911 call has a specific and well-established meaning. It's referencing the emergency call placed on the day that Andrea Matthews died. That event has been repeatedly discussed across these channels and has become a central subject of an ongoing commentary and narrative surrounding William Bartell. So the legal question isn't whether Brian explicitly spoke a protected name. The real question is, would a reasonable listener familiar with this ongoing narrative immediately understand what and who he is referencing? And based on the surrounding context, the answer is arguably yes. There is another detail here that matters, the rest in peace reference. This is tied directly to Andrea. Again, that may sound indirect on its face, just saying rest in peace, but when paired with the reference to the 911 call, the ongoing narrative in Brian's channel, it narrows the meaning considerably. This is no longer random commentary. It becomes a contextual reference to a specific event involving specific protected individual that Brian's established audience would readily identify. Now, under the framework of the temporary protection order, indirect reference can still be legally significant if the target is reasonably identifiable. Courts often evaluate these issues through context, audience understanding, and surrounding circumstances, not just whether a name was spoken aloud. Standing alone, this clip may not conclusively establish a violation, but it does establish an important pattern. Post-service, Brian continues using coded or contextual references to discuss subject matter his audience already associates with William and Andrea. And as we move through the next clip, the pattern becomes much harder to dismiss as coincidence. Let's go to clip 2.
Six Oak says if there's a plea deal on the table, the state wants something from him, likely the ID of Killa, hence the channel removal, and or the ID of the donor that facilitates Willie B's trip to Indiana. Oh, yeah.
This clip may seem shorter and less direct than some of the others, but it raises an important issue when viewed in context. The focus here is Brian's use of the phrase Willie B. Once again, someone unfamiliar with the background may argue that it's too vague to identify any particular person. And that would likely be the immediate defence. No full name was used, no protected individual was explicitly identified. But what that argument depends on entirely on ignoring context. Within Brian's community, Willie B is not some random nickname. It's an established shorthand reference understood by Brian's audience to mean William Bartell. That matters because courts evaluating indirect reference do not limit themselves to literal wording alone. They look at whether the intended audience would reasonably understand who was being referenced. And here, audience recognition is critical. If Brian's regular viewers immediately understood Willie B to mean William Bartell, then the omission of a full legal name does not necessarily eliminate the legal significance of the statement. And Brian's statement, Willie B's trip to Indiana, then Brian's community knows that William is currently facing charges for felony stalking over a recent visit to Indiana. The law often examines substance over technical wording. A respondent cannot necessarily avoid scrutiny simply by substituting a nickname, euphemism, or coded identifier for a full name if that target remains readily identifiable. There's another factor worth noting here, pattern. This is not isolated ambiguous phrasing appearing in a vacuum. It appears alongside repeated references across multiple clips to the 911 call, Andrea's death, affiliated commentary channels and discussing the same subject, and a broader contextual cues that are familiar to Brian's audience. When viewed together, these repeated references create a framework of identification. Each individual phrase may be framed as vague on its own, but taken collectively, they form a recognisable pattern pointing towards the same protected individuals. This is exactly why contextual analysis matters. The legal question is not, could these words theoretically refer to someone else? The legal question is, would Brian's intended audience understand who he meant? And based on the surrounding circumstances, there's a substantial argument that they would. Standing alone, clip 2 may be circumstantial, but as part of a broader sequence of post-surface references, it strengthens the argument that Brian continued identifying protected parties through indirect but recognisable language. Now, let's move on to clip 3, where the conduct becomes significantly more explicit through third-party redirection.
So, like I said, guys, there was a particular 911 call that was made 1 year ago. We're about halfway through it, guys. I can reference a 911 call. I know that there is a particular channel that is going to be discussing a 911 call. I highly recommend that you go. I highly recommend that you go and support that channel. Check it out. You should share that 911 call wide and far. You're not forgotten. And we're going to get you to be able to rest in peace at some point in time. Go ahead and put the link to the channel that I'm talking about in the description, guys. Make sure you show up. I think they're going to be discussing the video that came out this morning on that channel. And I don't know. We'll see. I'll say God's timing is miraculous. That person that'll be putting out the calls got all of the calls about a day and a half, well, 2.5 days ago now. Some of you know that I did get served and I'm not allowed to talk about certain things.
This clip is where the analysis becomes substantially more serious. Why? Because we're no longer dealing with vague passing reference. We're looking at a combination of 3 separate elements that when taken together create a much stronger argument for indirect prohibited conduct. Let's break them down. First, Brian again references the 911 call. As we established earlier, within this audience, that is not some generic phrase. It points to a very specific event. The emergency call that connected to Andrea Matthews' death. That subject has been repeatedly discussed across this content ecosystem, and Brian's audience understands exactly what is being referenced. Second, Brian directs his viewers toward another channel. And this matters because this is not an unrelated third party. This is a channel that has appeared on Brian's livestream panel and is actively covering the same underlying subject matter. This creates continuity. This is part of the same commentary network discussed, the same protected individuals and the same underlying event. Now here's where this becomes particularly significant. Brian had already acknowledged being served with a temporary protection order. So when a respondent, after notice of that order, redirects his audience towards affiliated third-party coverage of the same prohibited subject matter, that raises an obvious legal question. Is this an attempt to continue participation indirectly through amplification rather than direct commentary? That's exactly the kind of circumvention issues that courts often scrutinise. The law generally looks at substance over form. In other words, a respondent cannot necessarily avoid responsibility by saying, I didn't say it myself. I just sent people to someone else who did. The third element is timing. This happened after service. And that timing matters because it removes any argument that Brian was unaware of the restrictions or unclear about the seriousness of the order. He had already publicly acknowledged that he had been served. He understood the order existed, and he was already complying with at least some of its immediate requirements. That makes subsequent conduct far more legally relevant. Now, to be precise, this clip alone, once again, does not automatically prove a violation, but it does present a pattern of behaviour that a court could reasonably interpret as deliberate indirect continuation of protected topic commentary through collaborative third-party channel. And when we pair this with the next clip, where Bryant explicitly encourages wider dissemination of this material, well, the potential implications become even harder to ignore. Let's move on to clip 4.
And I will tell you guys this before we head out, before I end the stream. Go support it. Share it far and wide. Even if you got a small channel, share the link. If you're able to share the link, share the link. Share the link to the video. Put it on your Facebook. Share it on Facebook. You never know. The right person might see something, might know something, might hear something. All right?
Of all the clips we've examined so far, this is the one that raises the most significant questions under the temporary protection order. And the reason isn't simply that Bryant references the underlying controversy, it's what he tells his audience to do. Let's take a look at the language carefully. Bryant repeatedly says, share the link. Not once, not twice, but multiple times. He then expands that instruction. Put it on your Facebook. Share it far and wide. The right person might see something, might know something, might hear something. Now, taken in isolation, encouraging viewers to share content is something content creators do every day. But context matters. The question isn't whether sharing content is normally legal. The question is what content is being shared and who is it about. By this point in the stream, Bryant has already directed viewers towards a channel discussing the same 911 call controversy we've already identified, a controversy that his audience associates with William Bartell and Andrea Matthews. This is no longer a generic request to support a creator. This is a request to amplify content relating to a dispute involving protected individuals. And that distinction is important, because a court examining this conduct could reasonably ask if a respondent is prohibited from direct or indirect electronic conduct involving protected persons, does encouraging hundreds of followers to spread related content across social media amount to indirect participation? That's not a hypothetical question. That's the issue this clip puts on the table. Notice something else Bryant doesn't merely say. Watch the video. He encourages dissemination. He encourages distribution. He encourages expansion of the audience, and specifically suggests that unknown third parties may come forward as a result. The right person might see something. The right person might know something. The right person might hear something. Those statements can be interpreted as encouraging further investigation, discussion, or public engagement surrounding the underlying allegations. Again, that doesn't automatically establish a violation, but is exactly the sort of conduct a petitioner could likely point out when arguing that a respondent continued to involve himself in the controversy indirectly after service of the order. And there's another factor that makes this clip particularly difficult to dismiss. By the time this statement is made, Bryant has already acknowledged he was served. He's already acknowledged the existence of the temporary protection order. So we're not dealing with pre-service conduct. We're not dealing with someone who can claim ignorance. We're looking at statements made after notice. That timing is critical because it allows the court to focus not only what was said, but whether it was done knowingly. Taken together, Clip 4 presents the strongest argument so far that Bryant was not merely commenting on a matter of public interest. Rather, a court could conclude that he was actively encouraging wider dissemination of content relating to protected individuals, despite knowing that an injunction was already in place. Whether a judge ultimately agrees is a separate question, but from an evidentiary standpoint, this is arguably the most significant clip we've reviewed. And now we come to the final clip, where Brian directly addresses the temporary protection order itself and refers to the petitioner through language his audience would immediately recognise.
And we'll catch you. Thank you. Mr. Mimsy put it in there. Definitely check it out. I believe Mr. Mimsy is going to be on that panel. Unfortunately, a former freedom fighter decided they wanted to put a particular TPO on me, just like Chris Ryder did, trying to silence me. When you rip a tongue out of a man's mouth, it's not to prove he was a liar, it's that you're afraid of what he might say. I'll keep it at that. Not only that, that patriotic freedom fighter. My wife and I had to surrender our weapons today. Again, second time in 10 months now. Not happy about it. I believe there's going to be a reckoning involved in that, guys.
Unlike the earlier references to the 911 call or the promotion of third-party content, here Brian addresses the temporary protection order directly. And in doing so, he provides some of the strongest evidence yet that he knew exactly what the restrictions had been imposed. Let's start with the obvious. Brian states, a former freedom fighter decided they wanted to put a particular TPO on me. Now, once again, no name is spoken, but we've already discussed the importance of audience recognition. The relevant question isn't whether a stranger on the internet would understand who Brian is talking about. The relevant question is whether Brian's audience would understand who he is talking about. And based on the history of this dispute, there is a strong argument that they would. Within this community, freedom fighter is not a generic term. It has a specific contextual meaning tied to William Barthel. If the audience immediately recognises the reference, then the absence of a full legal name might not carry much weight. Context matters, and context is exactly what courts look for when determining whether indirect references are, in reality, directed at a protected person. But there is another statement in this clip that may be even more important. Brian says, when you rip a tongue out of a man's mouth, it's not to prove he was a liar. It's you're afraid of what he might say. Now that's a powerful rhetorical statement. It's also revealing because it frames the temporary protection order not as a legal order that must be obeyed, but as an attempt to silence him. And that framing is significant because it can help explain the pattern we've seen through the earlier clips. Throughout the stream, Brian has repeatedly references the same underlying controversy, while simultaneously suggesting that he cannot discuss it openly. In other words, a petitioner could argue that Bryant was attempting to continue the conversation indirectly while portraying himself as being prevented from speaking directly. Whether that argument succeeds is ultimately up to a judge. But it's easy to see why a petitioner would point to this statement as evidence of intent. Bryant then adds another important fact. My wife and I had to surrender our weapons today. Why does that matter? Because it further confirms that Bryant understood that the order was real, immediate, and legally significant. This wasn't a situation where the injunction had been forgotten or overlooked. According to Bryant's own statements, he was actively complying with portions of the order on the very day these comments were made. That makes it much harder to argue that subsequent references to protected individuals or protected subject matter were accidental or uninformed. Once again, taken by itself, Clip 5 may not be the strongest evidence of a violation, but it's arguably the strongest evidence of knowledge. Knowledge of the order, knowledge of the restrictions, and knowledge of the legal consequences. And when you combine that knowledge with the earlier clips, references to the 911 call, references to Willie B, directing viewers to affiliated channels and encouraging widespread dissemination of related content, the overall picture becomes more significant. Not because any single statement conclusively proves a violation, but because the clips viewed together, create a pattern that a court could reasonably examine and ask, was this an attempt to continue discussing protected individuals through coded references, audience familiarity, and third-party amplification after a service or a temporary protection order? That's ultimately the question at the heart of this case. And it's a question that may soon be answered in court. 6/9/2026. Now I have one more thing to show you before ending this video. We've just heard that Brian said that Mr. Mimsy put a link into the chat. Well, this is the link here, alright, and it's to Dave Finkel's channel. So if we click on that, we're going to go to Shadow Finkel. And if we now go to his videos, actually we'll go to his lives. 911 call, 911 call, 911 call. I believe that's 911 as well. So yeah, Shadow Finkel has been doing the 911 calls as well. Well, that's all I've got for you for this video. If you've liked this video, please subscribe, give me a thumbs up, and leave a comment. Until next time, bye.